Right. Hello, everyone. I'd like to thank Merton Mencap for asking me to do this talk and you for giving up your morning to come and hear it. If you haven't come across our organisation, we're a charity that supports particularly parents and carers and young people with everything to do with accessing the right support for children with SEN in education, particularly on the legal side. And I'm legal officer with the charity and previously was in private practice doing legal aid work. So I've been around a long, long time. Um, doing this talk is sort of split into two halves. One is about appeals, the other is a sort of update on a number of things of fairly recent developments in SEN law. Appeals is a big, big subject. So I'm afraid this is, we've got a lot of slides because I'm not going to have time to go through it all in detail. But I thought I would put at least some of the detail onto the slides so that you can read them all later. And I'm very happy for the slides to be shared. If we could dive in and go to the first slide, or go to the next slide rather. This is just where you find the relevant law. I'm not suggesting you print all of this stuff off because trees, but they are all available online. The Children and Families Act gives the basic provisions around the law that's now operated for SEN at the moment. The SEND regulations of 2014 um, put quite a lot of more detail in, particularly around things like timetables and what should happen during assessments and annual reviews and so on. And the code of practice, as it were, sits under them. And I put that in bold because it's the most sort of user-friendly of these documents. And it puts even more sort of flesh on the bones. But it is technically guidance. The other two are the law that have to be complied with. This is guidance, which means it doesn't necessarily have to be complied with. However, when it's using the word must, that means it's sort of quoting the law. When it's using the word should, it's good practice. People like local authorities and schools should be following it unless there's a good reason not to. But over the years since 2014-15, there have been cases where it's been tested in the courts or the upper tribunal, and one or two aspects of the code of practice have been found to be incorrect. So if there's any sort of conflict, then the Act and the regulations win. And the other thing to be aware of in this connection is the tribunal rules, which you've got as the fourth bullet point there. And again, that's available online. And there's also lots of other information around, including in particular notes attached to the forms that you use for appeals, which are the SEN 35A and SEN 35. Could we have the next slide? So just a word about terminology in this talk. We're talking about the law that applies from the age of 0 to 25, and it distinguishes between children and young people. Young people in this context are people who are past statutory school leaving age, which is the last Friday in June in the school year. They reach the age of 16. And the significance of that is when they become a young person, uh, uh, provided that they have the required mental capacity, which is effectively ability to understand what it's about, then a lot of the right to make decisions passes to the young person. So things like applying for an EHCP, being consulted for annual review purposes, being consulted about amendments, and in particular the right to appeal passes to them. There is still an assumption that parents and carers will be very closely involved. And if you're concerned about that, and many parents, not surprisingly, are, you and indeed a lot of young people really don't want to have to make these decisions. It's perfectly fine for them to sign a document that says something to the effect of, I confirm that I would prefer my parents to continue making decisions about my education, or I would confirm I would like my parents to um, to to basically run my appeal for me. And if that's signed and dated, provided they understand what they are signing, that is fine. Um, when they're 18, they could do a power of attorney. They could also deal with set up a deputyship, which is a more complex document which covers things like financial affairs and so on as well. But the basic right is theirs. And when we talk about mental capacity, it's quite a low bar. It doesn't mean they would have to be capable of running the entire appeal for themselves. They have to basically understand what it's about, and make basic decisions that, for instance, they would like to move to a different school, and they feel they need more support, that type of thing. Just during this talk, if I talk, I tend to talk more about children, but usually I will mean children and young people, unless I say otherwise. CYP is an abbreviation for children and young people. Again, if I'm talking about parents, I'm generally talking about parents and carers. And if I'm talking about schools, I'm talking about any sort of educational institution. LA is local authority. ICB is the Integrated Care Board, what used to be the Clinical Commissioning Group, which is essentially your local group of health services. CFA is the Children and Families Act 2014. There will be other abbreviations during the talk, but I hope they'll be fairly obvious what they are or explained as I go along. So next slide, please. What can you appeal against? Well, basically, it's if you look at the stages of assessment, the first thing is that you are asking them to assess. If they refuse within 6 weeks, you have a right to appeal. So they have to. So they should do it within 6 weeks. They don't necessarily. If they agree to do an assessment but then refuse to issue an EHCP, you have a right to appeal against that. If they agree to issue an EHCP but you're not happy with it, you have a right to appeal against that. Also, if they amend an EHCP and you're not happy with the amended one. And when you're talking about an EHCP, your main right of appeal is in relation to section B, which is the one which deals with your child's needs, F, which is the provision to meet needs, and I, which is the placement. And it could be any combination of those. And they also now have extended powers to consider the sections that deal with health and social care, and they can make recommendations about those. Other things you can appeal is a refusal to amend after an annual review, or a decision to cease to maintain an EHCP. And in both of those, you could also, and you should also almost certainly appeal against the contents of the current EHCP, because the chances are that they're out of date anyway. And you can appeal if you think there is disability discrimination, but I'm not going to be talking about that today because that's a whole other complicated subject. Next slide, please. So your time limits for appeal, basically, you will receive a letter with the decision to refuse to assess or cease to maintain or whatever, or attaching the EHCP. And you've either got 2 months from the date of that letter or 30 days from the mediation certificate, because you have to have at least thought about mediation, and I'll talk about that in a minute. So it's whichever comes later. So if for any reason you wanted to delay starting your appeal, for instance, because an expert isn't available, then you might wait until sort of 7 weeks after the date of the decision letter to deal with mediation, because that will then give you another 30 days. But usually you will want to get on with it. Also, the tribunal doesn't really recognize August for many purposes. So if your deadline expires, say, the 15th of August, in practice, you still have until the 31st to get that appeal in. You can, it's not the absolute end of the world if you miss a deadline, because the tribunal has some discretion to allow late appeals, but you would have to have a very good reason not to get your appeal in time. And basically you don't want to have to rely on them using that discretion, so try to meet the deadlines. Next slide, please. So I said we're talking about mediation. You have to have at least talked to someone about mediation for any type of appeal, unless it is limited to Section I, and the decision letter you get from the local authority must tell you about that and must give you the details of a mediation advisor that you can contact. And basically, that is not a mediator, that's just someone whose job it is to tell you what it involves and answer questions. You don't have to agree to mediation. It's absolutely fine to say no. I've heard stories of some parents being told, "Oh, it'll tell against you. It's a black mark." No, it isn't. Nobody really cares. By definition, everybody who appeals has either not agreed to mediation or they've tried it and it didn't work. So it's not a problem. And if you refuse mediation, then they must issue a mediation certificate within 3 days, and you need that because they won't accept your appeal without it. If you do go for mediation, it's normally going to be paid for by the local authority because the mediator needs to be paid. Or if you are dealing with health issues, then the ICB will contribute. Some people worry that that'll make them biased. I don't think that is the case. Mediation companies are generally quite big companies with a number of local authorities on their books, and they have no real reason to favour anyone. And anyway, they're not making decisions. They are only there to try to facilitate each of you sort of reaching some sort of agreement with each other. Next slide, please. So if you do decide to mediate, then the mediation company will get in touch with the local authority and they'll aim to arrange it as soon as possible. They've got to at least have made the arrangements within 30 days. But it doesn't necessarily mean the meeting has to happen within 30 days, but they should get onto it. By law, the local authority are supposed to respond and cooperate, but unfortunately, there are a number of authorities that don't. And if they don't, the mediator will issue a mediation certificate after 30 days. And you can then make a decision. Do I want to just forget mediating and get on with my appeal? Or you could actually put an appeal in and still say you want to mediate. And actually, that can be quite healthy because at that point, the local authority knows that the clock has started running on your appeal and they may concentrate a bit more. You can mediate about health and social care issues as well as education. And if that happens, then people from those departments should attend. And the local authority is supposed to send someone with authority to make decisions, or at least a hotline to someone who's got authority to make decisions. And I would check with the mediator that they are doing that, because you do not want a situation where you think you've tied everything up and they say, "Oh no, I've got to go and ask the panel." Is meant to be sort of bring an end to this. Nowadays, the vast majority of mediations are online, but you can ask for a face-to-face meeting if you prefer that. Next slide, please. Yeah, well, the process works fairly informally. Usually, the mediator will phone the parties beforehand just to talk about what they want to get out of it and to tell them how it'll work. But when it's online, or indeed if it's in person, there will usually be arrangement where each of you, the local authority and the parents, have got, as it were, separate rooms where the mediator can talk to you separately. Most of the time, you would come together to try to iron out any sort of issues and try to reach agreement. If you do reach agreement, then the mediator will normally write that down in a mediation agreement. And that's an enforceable document. You can enforce it through various means, including judicial review. And I don't really have time to tell you about judicial review, but there's lots of information about that on our website if you'd like to look into it. If you do go for mediation and you reach an agreement, do make sure that any actions have time limits written in. I've seen mediation agreements that didn't. And, 6 months later, the parents coming to us saying, "What can I do?" They said they'd do these assessments and nothing has happened since. So if you've got a time limit in, that really helps. The whole thing is meant to be completely confidential and you can't refer to it in any subsequent appeal. And that's the fairness to both sides and to make sure that you feel free to negotiate. You don't want a situation where you were, for instance, to say to the local authority, "Well, okay, I'd be prepared to accept half of the speech and language therapy that I'm asking for if you give me more one-to-one. And then, you don't reach agreement, but you get to the appeal and they say, oh, but you agreed that half the speech and language therapy was going to be enough. That shouldn't be the case. So it's all, you can't refer to anything that you discussed if you have to carry on to an appeal. They will ask you to destroy any notes you might have taken. If they do it in person, they ask you to give in the notes so that they can destroy them, but presumably they have to rely on trust now. If it doesn't result in settlement or you only settle part of it, the mediator has got to issue a mediation certificate and you've then got a further 30 days to appeal. So you don't lose time by going through, you don't sort of miss time limits by going through this process. Whether you go for it is really a matter for you. We've had stories of people who said it was a total waste of time, other people who said it's fantastic, they sorted everything out. Generally speaking, it seems to stand a better chance of working on the simpler decisions, which are around sort of assessment and whether they're going to issue. If you're mediating about the contents of an EHCP, I would recommend strongly that you produce at the very least a list of the amendments you want, or even use the working document process, something similar to that, which I will talk about later, because it makes it much quicker and more focused if everyone knows exactly what the amendments are that you're asking for, or at least got an idea, and you're not scrabbling around sort of saying, oh, well, it's page 5, halfway down the page, we want to change the wording to this, and you're painfully dictating it. So, try and use the time as effectively as you can. The other aspect of this that you need to bear in mind now is that, as you may have heard, for the majority of appeals, unfortunately, there's a massive backlog and it takes about 50 weeks to get a hearing date. So sometimes you might need to sort of think about, well, shall I try mediation? Because at least that'll be quicker. Of course, the downside of that is if it doesn't work, then there's even more delay. So you've got to balance up how much you think it might work. Next slide, please.
My mouse just frozen.
Oh dear.
I'm sorry.
I'll start talking about the next slide anyway, whilst you do battle. I was going on to talk about the overriding objective. If you look at Rule 2 of the Tribunal Procedure Rules, this says, as it does for every tribunal, that the overriding objective of the rules is to enable the tribunal to deal with cases fairly and justly. And you might be saying, well, so I should hope. Not much point doing it otherwise. But it then goes on to explain what it means by that. And that is set out in the slide when we get there. And it says that it includes things like dealing with cases in a way that's proportionate to their importance and complexity and the likely costs and the resources of the parties. So that means, for instance, that you should not have a situation, as happened games like in the sub postmaster's case, where you may recall that it did rather look as if the post office tactics were to run up the costs so much that they would run out of funding. And that shouldn't happen in this type of case. They want to avoid unnecessary formality, to be flexible. They want to ensure, so far as is practicable, that everyone involved can participate fully, use their special expertise effectively, because at least one of the members will have some sort of specialization in SEN, and they will try to avoid delay so long as that doesn't prevent them from considering the issues properly. And the importance of all of this is really, I want particularly perhaps to focus on B, the one about avoiding unnecessary formality and flexibility. This is intended to be a user-friendly process, not one where you have to have a lawyer. I'm not saying don't have a lawyer, obviously, but probably the most appellants actually aren't represented, and they do have a very good success rate. So don't feel you have to have a lawyer. But what tends to put people off is thinking, not surprisingly, if you've never dealt with anything like this before, there are lots of rules and regulations, and I could get this wrong, and I could destroy my child's future if I don't get it absolutely right. And that is not the case. I mean, obviously, yes, do try to obey the rules, and especially any directions that the tribunal issues, and keep to time limits and so on. But it is not necessarily fatal if you don't. There is that flexibility, because what they're focusing on is we need to achieve the right result for this child, and they do not want a child who's going to be shut out of support they desperately need just because of a technicality. And for instance, I mean, I had a situation moderately recently where a parent was in absolute panic because they just hadn't noticed a deadline, and therefore they hadn't complied with it. And it was 2 or 3 weeks previously, and they were thinking, am I going to get struck out? Is this disastrous? But in fact, they didn't have a hearing until about December. So I was able to say, well, actually, no, because, send everything, do it all now, send everything off now. It was filing evidence, I think. Um, they cannot seriously suggest that they do not have time between now and December to read through your evidence and talk to people about it. They will not be prejudiced by this. But you need to make an application to the tribunal for permission for it to be accepted at late, and you need to grovel and say you're really sorry, but you don't think there'll be prejudice, so please, can I have time? And sure enough, that is what happened. So, as I say, don't, obviously try to get it right, but don't be scared that you might do something disastrous, because the chances are you won't. Not unless you completely ignore everything that ever comes from the tribunal. So next slide, please. So who can appeal? Well, for the vast majority of cases, it's going to be the parent or carer, including foster parents for children. If it's a young person and they've got the required mental capacity, then the appeal has to be in their name. If they don't have capacity, then again, they're going to need a representative who will normally be the parent or carer. And technically, they're called an alternative person, but you don't really have to worry too much about the terminology. And again, you don't necessarily have to worry too much about the care, whether they've got capacity. There is an assumption that people have capacity, and therefore, if you say they've got capacity and they sign it in their name, then unless the local authority objects, that would be accepted. And equally, if you say they don't have capacity and you do it, unless the local authority objects, that would be accepted. I've had cases, again, not surprisingly, people have been used to doing these things with their children all their lives, and they just carry on when they're 16, 17. And then the local authority says, well, we think they've got capacity. What's wrong here? And again, you don't need to panic about that you've started it in the wrong name. You could just go to the tribunal and more or less say, oops, sorry, didn't realize. Please, can we swap his name? I'll still be the representative, and carry on. And it will, in my experience, it will just go through without any problems. Next slide, please. Just quickly looking at the forms, if it's a refusal to assess appeal, it's a form 35A, and it focuses on the legal test for assessing, which is summarized there. Is basically whether your child may have SEN, whether they may need support through an EHCP. And we would suggest, in fact, that when you fill that in, it's got those questions. It's got a fairly small box, but doesn't give you much space. And it says carry on another piece of paper. We would suggest that rather than do that, because people will be flipping back and forth between the form and that, you'd simply put in that box. Sorry, could we keep test questions for the end? I'll have a break at the end of the appeal section, because I might cover your questions when we get there, and sort of in the course of this anyway. We would suggest that you just see attached appeal grounds in that in the form. I would like to emphasize all of this is just recommendations. If you've already started your appeal and you've done it differently from me, don't worry about it. I'm not saying this is the only right way to do it at all, but I'll come on to why we suggest that. And I mean, I suppose really what we're suggesting in all cases is that you do this because it just lets you put everything into a nice logical consecutive order that sort of reads through from the introduction to the background to what you're appealing about, and is just an easier way for people to access what it's all about. So next slide, please. It's 735 is the one for absolutely everybody else. So sometimes you have to be a little bit selective about the questions, because it'll ask you things about what do you say is wrong with the description of needs. And if you're only appealing against a refusal to issue, you haven't got to that stage yet. But it's reasonably obvious when you have a look at it. And again, we'd suggest you having separate appeal grounds. So next slide. So, question, are there any rules about this? And as I've said, no, there aren't. Just a few sort of overall points. Please keep your appeal grounds reasonably succinct and easy to read. Do not write 50 pages. It won't be particularly helpful. When you're a busy tribunal judge and you're faced with a mass of documents, it doesn't put you into a particularly good mood. So that means, not rambling. What they are mostly focused on is, how is your child now? What do they need in the future? It doesn't mean the past is irrelevant, because it's quite important to show how you got here, as it were, particularly for children who've had a long history of problems at school and changes at school and that type of thing, but not every single dreadful thing that happened to your child at school. And generally speaking, if you're filing reports and so on, they will read those. There's not really any point in quoting large chunks. They don't want to have to read everything twice. You might quote little bits. For example, if every single expert is unanimous that your child needs a special school, you might do a few sort of choice quotes that illustrate that, but not the whole lot. And I think to make it easy to navigate, it's helpful to have separate headings to break it up, like background assessments, what my child's SEN are, this type of thing. And for a contents appeal, then use the headings and subheadings for each section of the EHCP that you're challenging. So next slide. This bit I am going to sort of slip through fairly quickly, because it takes there's a lot of material here and we've got a lot to cover. I'm not here to advertise, but coincidentally, as it happens, we're running a webinar this evening about drafting appeal grounds, and you can probably still book for it. So if you're interested, that will go into much, much, much more detail. But generally speaking, for your strategy, I think it's helpful to anticipate the points the local authorities are likely to make. You'll probably have a good idea from what they've said to you already. So if they are saying, for instance, that they won't accept your school because it's too expensive, then you can anticipate that, and you can say, no, it's not more expensive, when you take into account the fact that they'll have to employ a one-to-one and they'll have to pay for transport, blah, blah, blah. Or you might say, yes, it is more expensive, but the school they're offering clearly can't meet my child's needs. So in a way, you've slightly wrong-footed them by making that point before they can do it and saying why it's wrong. You don't need to quote acres of law. The tribunal knows the law, and being told effectively, how to suck eggs is not going to impress them. You might, however, need to cite some things, again, to cover the sort of arguments that the local authority is likely to make. A classic one nowadays is, we don't have to, it's not a good idea to be too rigid about specifying support, which is not really true. Yes, there's some flexibility is required, but there is case law that says the norm, nevertheless, should be to be reasonably specific and detailed, unless there's a good reason not to. And for a school appeal, your strategy, I think, needs to bear in mind that the school that's named in section F has to be capable of delivering the school that's named in section I has to be capable of delivering what's in section F, and in turn that has to be capable of meeting the needs described in section B. So in most cases, you need, if you're contesting the school, the chances are that you also need to contest F and B, because For instance, if they are talking about a mainstream school, they will have written section F to fit their school. And it'll have fairly vague provision, almost certainly, that any mainstream school could supply. So if you're saying that your child needs a specialist provision, if you don't challenge section F, then the tribunal is going to be stuck, because it's got to name a school that can meet section F. It's got to bear in mind the cost. The mainstream school will almost certainly be cheaper than the specialist school, and you will not win. So ideally, what you want in section F is provision that your school can deliver and the local authority one can't. So if it's a specialist school, you would expect to see things like small classes, specialist teachers, appropriate peer group, maybe therapists on site, and specialist equipment and so on. But you will not get that in there unless there are professionals who are advising on things. Why? Next slide, please. So I'm going to go through this quickly. Start with the background information, which more or less says how you've got here. Then go on, particularly if you're talking about refusal to assess, refusal to issue, to talk about the SEN that your child has. Obviously, if you're appealing against the contents of an EHCP, you would hope that it does describe already what they have, but maybe a summary anyway. Next slide. And you then go on to address the tests. So the legal tests for if it's a refusal to assess or refusal to issue, appeal, equally, actually, if it's a cease to maintain appeal, which I haven't really dealt with here, but you can see what the tests for that are in the Code of Practice. But for refusal to assess, it's the test I mentioned, whether your child may have SEN, may need support through an EHC plan. Refusal to issue, whether your child might need support over and above what's usually available through normal mainstream school resources, and refer to the evidence that supports that argument. And you may have a lot of that already. If your child is not making any progress, that's a good indicator that their needs can't be met. If people have, if say an educational psychologist has recommended that your child has one-to-one, or indeed if the school is saying your child needs one-to-one but we can't afford to deliver it, that's more than's usually available. Equally, if they're saying they need speech therapy but there's a massive queue for speech therapy, again, that's something which they can't deliver through normal mainstream resources. So they should be, have a good look at what evidence you've got already to support that. Next slide. So go on to, if you're talking about contents, have those headings and subheadings. Section B, you're basically looking about whether they've properly described all the needs, especially how severe they are, how they affect learning. It's not good enough just to have a list that says he's got literacy problems, he's got speech problems, he's got numeracy problems. You need to know how severe they are, because those things will cover a very wide range. Section F, you want to see provision for each and every need. Is the reason why it's inadequate that they didn't carry out the right assessments? Is it up to date? Is it properly adequately detailed and specific? Not absolutely everything, but there needs to be enough in there so that people working with that child know what they're meant to be doing, and so that it could be enforced if possible. And I want to be looking for what we would call weasel words, things like may benefit from, which is basically saying it might be nice, as appropriate, which regular could be anything. But if it's not adequately detailed and it's talking about things like regular speech therapy, if you want that defined, you are again probably going to need an expert to say what it is. Is it weekly, termly, monthly? Is it one-to-one? Is it in a small group? Is it a program, etc.? Does it properly affect the reports, particularly have they artistically left out anything that might be expensive or might point to a special school, and can the school actually deliver it? Next slide, please. Yeah, and equally, if you're asking them to look at health and social care, again, have subheadings for those. If it's social care, it is worth, if you haven't had a care assessment, it's worth asking for one, because practically any child who qualifies for an EHCP is likely to qualify for a care assessment, because they will probably meet the definition for being disabled, which is one of the sort of criteria. But having said that, we do find care assessments often don't result in anything terribly helpful. It will be something like, here are the local activities and here's some parenting classes. But if your child does have care needs, that really is the first step, and you should ask for it, and that should be set out in the HCP. And it is worth, I know they can only make recommendations about these, but it is worth thinking about it, because it's not that they can just be ignored. They have to, if they make recommendations, social services or health have to write within 5 weeks saying whether they accept them, and if not, why not. And if they don't have any rational reason or reasonable grounds for not accepting it, you can challenge it through the Ombudsman or through judicial review. Next slide, please. Yes, this is all slightly technical, so I think I won't take too much time going through it. But basically, when it comes to placement, the law says they must meet your preference if it's a qualifying school, which is that list there. A Section 41 school is an independent school that's on a list maintained by the Department for Education. It doesn't make it a better school. It's just said it would be prepared to be on that list. And if, generally speaking, the rule is that they must sorry, they must meet your preference unless it's unsuitable, or the placement is incompatible with the efficient use of resources or efficient education of other pupils. And efficient use of resources is one they probably use most often, because basically they're saying it's too expensive. If you prefer a mainstream school, then the law's in your favour. The only ground they can refuse is it's incompatible with efficient education of other pupils. And there's a lot of case law that says it really has to be quite an extreme situation for them to satisfy that, and they have to show that there's no reasonable steps they could take to get over that. And the rest of that slide I talked about already. So next one, please. So what do you lodge with the appeal? Well, you have to lodge the decision letter and the mediation certificate, unless it's a Section I case. And if it's an appeal against contents, you have to lodge the EHCP. Also, the annexes listed in Section K, if you've got them. If you haven't, don't worry about it. The local authority will have to do it. And the rest is relevant evidence. And I stress relevant. There's a temptation to shove everything in. It will not help. You must keep it really to what's relevant to how your child is now, what they need in the future. And there's some suggestions there. With things like video recordings, you could send it on a memory stick. You can do it with links to things like a private YouTube channel. They're quite flexible about it. But if you use video recordings, keep them short, because they're not going to sit down for hours looking at them. Next slide. So, I mean, file what you've got at the time you deliver the appeal, but there will be a late evidence deadline, which is usually around 14 weeks after the appeal is registered. Bear in mind there is a page cap now, which I won't go through that. You can see it there. The page cap doesn't include any of the sort of appeal documents, the response, any tribunal orders, nor does it include the original EHCP and annexes. So you do need to bear that cap in mind, and limit what you file. It's not the absolute end of the world if you go over, but the tribunal is saying it's going to tighten up on this. So, try not to. If it's a school appeal, you are going to have to file the prospectus for the school you want and their latest Ofsted report. If possible, details of the costs involved. You probably won't have all of them, especially if it's a maintained school. But if it's an independent school, you should know what at least the fees are. So next slide. Process. Well, when you're lodging it, you can do it by post or email. Most people seem to do it by email, and they give you the address. If you email, bear in mind they get thousands of emails. Anything you can do to help them sort it. So put at the top their name, your child's name, date of birth, and in capital letters put new appeal. they will then go away and register them. You don't have to send this to the local authority because the tribunal will send it once it's registered. Assuming it's happy with everything, you will get a long letter and lots of directions around 2 to 3 weeks after after you have sent it in. And I'll talk a bit more about what's in there subsequently. So if we go to the next slide. So for a refusal to assess appeal, these are normally dealt with on the papers, which means there is no hearing. You can ask for a hearing if you want to, but frankly, I wouldn't bother. It doesn't seem to help. And actually it might give the local authority more of a chance to obfuscate things a bit. So from the day of data registration, the local authority has 6 weeks to put in a response. There'll be a final evidence deadline only a week or two after that. The reason they don't give more is that usually for this sort of case, you don't need a massive amount of evidence because it is such a low bar and you can file it all when you put the appeal in. Then there will then be a date when the local authority has to put together all the documents that have been filed in a bundle in a sort of defined order and has got to send that to you and the tribunal, and it has to send you a paper copy. They are very keen on that because you shouldn't assume that parents have printers and so on. And then there will be a sort of a notional hearing round about week 10. And it's not a hearing that you go to. It's the judges will basically meet up and make a decision, and you should get the decision sort of a couple of weeks after that. That's slightly is not necessarily defined. I think sometimes they send you a fortnight or something or a month where and say they will meet at some point in that period, because the great thing about these appeals is that they can slot them in quite quickly if another case is cancelled, and so it can be dealt with quite soon. So next slide, please. This is the timetable for every other type of appeal, and as I mentioned, it's painfully slow. You've again got 6 weeks for a response, 14 weeks for the final evidence. Case review forms have to go in a week or two after that, and I'll talk about them. This is a newish thing. And at the same time, local authority must send the hearing bundle, and there will then be a case management review in the couple of weeks after that. And the hearing might happen any time between 18 to 50 weeks-ish after that, and it'll be about 2 weeks after the hearing that you'll get a decision. They do classify some appeals as urgent, and those are mostly the change of phase appeals for things like primary to secondary, secondary to post-16. And they prioritise those so that they want to try to get those out of the way before the September when the child is due to start their new school. Also, cases where children are out of school, they will regard those as urgent, and they try to keep some slots back so that they can fit those in. And so they will usually do those within around 18, 20 weeks. And you could ask for an early hearing if there's other reasons why your case is urgent, like family reasons. And you could equally ask for it to be adjourned. They have also just started, or they're about to start, I'm not quite sure whether they put it into effect yet, something whereby if you're only appealing against the school, they will also expedite that to about 16 weeks. And that's why I said that we don't, I sort of put a slight qualification on saying you should normally always appeal against F and B, because obviously if you need your child to be in school quickly, then this is an attractive option. I mean, I would really only do it if it's an obvious case. I mean, I was talking to someone recently where the local authority hadn't named any school, hadn't managed to find one. The EHCP fully recognised that the child needed to be in a specialist school, and they hadn't even found a specialist school, let alone a mainstream school, to take that child. And that is, clearly that child needs to be in school. If the local authority has not found any alternative to the school that the parent wants, then you stand a very, very good chance of winning. It's in your interest to expedite that. And if there are problems with the EHCP, then there'll be an annual review and you can hope to iron them out then. So it might be worth thinking about. And also, if they get through all the urgent ones and find themselves with empty slots, they will bring cases forward. They did this last year, caused a bit of sort of concern. People who thought they had until February suddenly had hearings in October. So be aware that's possible. That's why they want everything to be ready by week 18. But I gather they will consult you in case it's going to cause massive problems, like your experts not being available. So next slide. So local authority response, you will get these directions, which, amongst other things, tell the local authority that they must address the legal tests that they're required to use. So it is things like that section 36.8 test for refusal to assess. And with the school, it's things like section 33 and section 39. They have to show that they've addressed those. And it is important that they do this. And you don't, if you get a waffly response that says, well, you know, we think we were right, so there, and nothing more, I would be challenging that. And first we'll get onto the local authority and say, look, you are supposed to address the response and address the legal tests. And if you don't do it, I will be applying to the tribunal. I mean, the tribunal has done this. They've tightened up on this quite a lot because they do regularly find local authority decision makers who do not know what the legal tests are. If they appear in front of them, it clearly comes as a surprise to them, and they have said that. And they hope that by forcing them to think about the tests, it will force at least some of them to realise that they don't actually have a reason that meets those tests. And if that's the case, they are going to lose. And so they would rather that the local authority concedes early, that rather than goes all the way through a hearing. Equally, don't worry if you get a great long legalistic response quoting masses of case law. We do see that. And I think sometimes it's just a ploy to get the parent worried. Again, frankly, I think it's liable to, if anything, it's going to annoy the tribunal because they are teaching them things that they already know. And it's designed to worry you. Do not be worried by it. You know, the odds are heavily in your favour that you will win. They are required to include the child's views, which may seem counterintuitive, but that's what the directions say. They will tend to get those from a teacher or an educational psychologist. If you don't think it's correct, there's absolutely nothing to stop you putting them in yourself. Next slide, please. Now, this is important, and again, this is something that is quite new. And I do emphasize that, again, when you get those directions, please read them, please note your own deadlines and the local authority's deadlines, and note what the local authority is required to file. And there's a lot of detail in this, and we're regularly finding local authorities ignore it. And again, this is aimed at making them focus their minds on, do they actually have evidence? And is it adequate? So they will be given directions to file these. And this isn't comprehensive, but it's I think it covers quite a lot of what they do. So it's everything they considered when they made the original decision, unless it's already been filed, a copy of their reasons for the decision, if they had a panel doing it, the child's attendance record for the last year, if this is a first EHCP or if it's refusal to assess, etc., then details of what's been happening at SEN support. And they want a signed and dated witness statement from the SENCO or someone in the leadership team at the current placement, which covers the issues in the appeal, whether they agree that this child needs to be assessed or needs an EHCP. If not, why not? If they agree that they're not making progress, etc. They want a chronology of events leading up to the appeal. If it's a child already with an EHCP, they want the last annual review documents. For school appeals, they want the consultation responses. Those can be really revealing, so I would absolutely push for them. If they're saying that, you know, this child can be in a maintained school, but every maintained school consultant said no, that's strong evidence on your favour, so push for it. And they're supposed to have witness statements from the proposed schools, which should cover things like how they would deal with your child, how they would meet their needs, and they are keen that they should give the actual costs to the school. Local authorities tend to put the cost to the local authority, but schools will always end up having to pay more to deliver what's in an EHCP, and that is still public money. It's a cost to the public purse, so the tribunal needs to know that. If they don't comply, I would get onto the local authority immediately and copy the tribunal into that. And you could make an application for them to be debarred or something like that, but it's probably better to leave it till the case review form. And I'll go into that later. So next slide, please. Witnesses, you can have up to 3 on each side, not including you or your representative. You could go above that, but they only have a limited amount of time for the hearing. It's a day normally for a school appeal. Everything else, it tends to be half a day. So if you have extra witnesses, there is a danger your hearing might get adjourned, and it won't just get adjourned to the next day. It could be several weeks, which is not great. For a school appeal, it's usually a good idea to have someone from the school that you want. And you will be asked in the case review form to give a list of your witnesses, and you'll have to say who they are in terms of, are they a teacher or an educational psychologist or whatever. And the tribunal has said they'll no longer accept lists that just say to be advised or similar. And that again is directed at local authorities mostly because they've had the experience, and they've said this, of someone turning up, at the hearing who no one's ever heard of, never met the child, no one knows what they're going to say, and they don't feel it's fair. And that basically, if that is tried, they will not be allowed in. They have to have been on that list, and they have to have done that a witness statement as set out in the bottom of the paragraph. Statement could be in the form of a report, could indeed be a letter, but they need to be something that sets out what they're going to say. You can ask someone to come along as an observer to support you, but they're not your representative or a witness. They can't take part in the hearing. You can have your child there. They like seeing the children. And of course, the great thing now is it's easier now. It's online. You're not having to haul them out of school. And for the child who would never leave his bedroom and is very happy dealing online, it's a good way to have their voice heard. If they do that, they'll usually come in only at the beginning of the hearing, and then normally the suggestion would be they go away because it's not good for them to sit there hearing themselves being discussed. And they will have a fairly informal session with just them, the panel, and you and the local authority rep, and not all the other witnesses. And they should try to sort of modify their language and ask sort of fairly open-ended questions like, what do you like school? What don't you like? What do you find helps you? What do you think about, where you'd like to go in September and this sort of thing? If you're very welcome to call your child. I think normally they probably accept them above the 3 because it's going to be a fairly short session. I mean, they can stay if they want to, of course. And older children, it might be appropriate, but not otherwise. So next slide, please. I mentioned making an application. You use a Send 7 form. Before you make an application, and there's stuff at the top of the want to make an application for, you have to have raised it with the other side, unless it is really, really urgent. The hearing's 2 days away and your witness has fallen under a bus or something, then that would be viewed as urgent. But if you don't raise it with the other side first, they will chuck the application back at you. So you can fill in the form and send it to them and say, do you object? Or you could just write to them saying, this is what I'm going to do. And I would give them 5 days to reply. If they don't reply, I would just carry on and put the application in. If they say yes, fine, then there's probably a good chance that the tribunal will just rubber stamp it. If they object, then still make the application. But in your application, deal with why you don't think that objection is valid. They will take at least 2 weeks to deal with it unless it's urgent. If it is urgent, then mark that in the heading of the email. But bear in mind that they get an awful lot of emails marked urgent that aren't urgent. So they're a bit cynical about that. So I would ring them up after you've sent it in and say, look, it really, really is urgent. This is why. Please, would you take it out of the list and put it in front of a judge? And I find that, despite the fact they're incredibly busy, they are really helpful. And if you're reasonable with them, they will be helpful to you. But otherwise, what they are tending to do now, in fact, is just to keep all applications together and consider them at the case management stage. So you don't be surprised if you don't hear for some time. Next slide, please. Okay. So yes, working documents. I mentioned this, a very important part of an appeal against the content of an EHCP. Normally, each side will be asked to work on this, and basically, this is a document where each of you has written in the amendments you wanted, and sort of to try to achieve the ideal EHCP. Obviously, only in the bits that you are appealing about. And the local authority should start that process by sending you an electronic version of the EHCP, and the format they require is that your amendments are in bold font, or if you want something struck out, you do bold font and a deletion. And you send that off to the local authority. If they accept your amendments, they put them back into ordinary font and underline it so the tribunal can see this is a change that's been agreed. If they don't accept it, they should just leave it in bold font. If they've got something different to suggest, then they should do the same, but they should use italics. And the idea is that you sort of bat that back and forth between yourselves and try to agree as much as possible. Be pragmatic about it. Don't get into silly disputes about 2 words, and be prepared to say, well, okay, that wording is not ideal, but it achieves what I want, so I'll leave it, I'll accept it. Or, you know, if you're close but not quite there, really think about compromising, because you know, if they're offering you, I don't know, 30 hours, so 25 hours one-to-one, and you want 30 hours, you have to think, well, am I going to risk losing this and go through a full hearing? Or shall I just try offer them a compromise of 28 hours, something like that? If there's substantive amendments, you know, if you're saying you're putting in a chunk of speech therapy that's been advised by a speech therapist, then you should put in a footnote to show where it's coming from, because they will not order amendments unless it's that type of amendment, unless it's been evidenced by a professional. And so you would use a footnote, and you would have in the footnote something like report of Mary Jones, speech therapist, paragraph 5.4, so they can see where it comes from. And in fact, what I tend to do is cut it down, and I will there's a key at the beginning, and I would extend that just to use initials. So MJ equals report of Mary Jones, speech and language therapist. JS equals report of John Smith, educational psychologist. And then I can just put MJ paragraph 5.3 in my footnote to make it nice and easy. And all of that helps to make it quite easy to follow. The idea is by the time you get to the tribunal, you have reduced it to only the things that are disagreed, and they can see quite easily what the issues are. If they see a big chunk of bold font about speech and language, then they know speech and language is an issue. If they can see every single reference to special school is in bold, they know that that's an issue. So that's the type of thing that it does make the hearing run much more efficiently again, but try to keep the length down. Don't have vast chunks of bits from the reports. I mean, the way I deal with this is probably the way a lot of people deal with it, is I would spread all the reports out. I'd arm myself with 2 highlighter pens in different colors, highlight everything that is provision in one color, highlight everything that's a description of the child's needs in another color, and then go through the relevant bits of the HCP line by line to see if they've been included. If not, and I think it's helpful, I'll write it in bold and put my footnote in. And it's a sort of organic process. I mean, I may see, you know, the educational psychologist has phrased support one way, but the speech therapist has added something to it, so I'll put them both together and footnote both of them. Or I decide the speech therapist actually phrased it better, so I'll use their wording, but I'll still say, well, yes, but my EP agrees with this, so I'll still footnote the EP. And where possible, try to reference the local authority reports, because obviously they'll be more disposed to accept those. You know, try and do that. One thing the tribunal is talking about now is, for any reason this process is not working, that instead you can simply do a list of issues. So something like, these are the issues I want you to decide: whether my child has dyslexia, whether they have a serious processing problem, whether they need one-to-one support, etc. But that is quite unusual, and they'll expect the parties to work together with that. Together, it's a useful process, but it's very fiddly, I'm afraid. I mean, I'm not sure we've yet done any webinars on this, because it is quite a fiddly thing to do, but it's the sort of thing that you might like to look into. Next slide, please. Yeah, so yeah, you're expected to start working on it sort of once the response is in. You may find you can't put all your amendments in because you're still waiting for an expert's report, but still do what you can and say, but I'll have to amend it later. And I said, be prepared to be flexible. If, and it does happen, the local authority just doesn't engage, raise that in the case review form. The tribunal takes a serious view of parties who don't engage, and they may be prepared to chuck them out. I mean, if they debar a local authority, that means the appeal continues, but they can't be involved in it. They are reluctant to strike out either side, particularly reluctant to strike out parents. So don't worry so much about that. So it's a last resort, but they have done it and they will do it. Next slide. So the local authority has to produce the document bundle in an order which is set out in rules, which you'll get. The directions are very, very tough and saying, if you do not produce this in time, you may be debarred, and they are prepared to do that. However, they can apply to be undebarred, and they will usually get it, provided that they do it very quickly, they've got a good reason for not having complied, and they have served the bundle by the time they apply. When you get that bundle, check it, make sure that everything you sent is in there, make sure it's all legible, make sure they haven't slipped anything extra in, and if there's any problem, let both the tribunal and the local authority know. If either side's gone above the page limit, it should all still be in the bundle. It's not for the local authorities to decide that you don't need your Red Psych report, and they will deal with any excesses at the beginning of the hearing. However, if they do find themselves with something which is going way, way, way above the page limits, then they do want the local authority to highlight it, and they may say to both sides, look, go away and concentrate on what are the important documents here, and check out the rest. So, do be aware of that, again, when you're filing documents. It doesn't help. If I'm faced with a 2,000 page bundle of documents that I've got to plow through, I'm not in a good mood. And you do tend to find at hearings that what it comes down to is a fairly limited number of reports and documents that each side is looking at. So next slide, please. Yes, I mentioned late evidence. There are deadlines. Please try to keep to them. But there may well be very good reasons why you have to file late evidence, especially with these long drawn out appeals. You have an annual review, or you got a pediatric report or something that is relevant. If that's the situation, you should send copies to the local authority and tribunal as soon as the evidence is available, so that they can't, particularly the local authority, can't complain they haven't had enough time to read it, and explain why you didn't lodge it earlier and why you think it's important. And I would, if you've got a hearing coming up, also phone the tribunal to make sure that copies, if the hearing is fairly soon, to make sure that the copies have gone to the judges who are dealing with the appeal. But the tribunal will usually decide whether they're going to admit it on the day of the hearing. They have a sort of a housekeeping session right at the beginning. And if it's sent less than 5 days before the hearing, it's really unlikely they'll accept it. You would have to have a very, very good reason for it being late, and it would have to be really, really important to the issues in the appeal. So next slide. I talked about the case review. They're required a week after the evidence deadline, and they ask fairly obvious questions about, so what are you still disagreeing about? Have you managed to settle anything? Are you ready for hearing? If not, why not? What do you still need to do? who are the representatives, including are they solicitors, local authority officers, charity reps, whatever, parental supporters if you want them, names and occupations of witnesses. They'll want to know whether they've produced a statement. Have you got any special requirements? And do you want it, are you okay with it being online, or do you want it in person? And there's an anything else box. And you might ignore that because it says anything else. But actually, I think that's almost the most important box, because that's the one to put in everything that needs to be tidied up before the hearing. So you might like to remind them that you've already applied for X, Y, and Z. Please, could you deal with those applications and highlight any other issues, like the fact that the local authority didn't comply with those directions, hasn't been responding to you on the working documents, or you're going to have to file some late evidence. Please, could you have permission for it? Please, could you bring an extra witness? That type of thing. So really important to think about, is there anything else I need to for this hearing, and put it in that box. Next slide. This is, I think, about the case management process itself. Once everything is in, the file goes to a judge. Won't necessarily be the judge who's at the hearing, and they'll decide, is this case ready for hearing? If not, do I need something to happen to make it ready? Do I need to adjourn it? They might well order a case management hearing, which is going to be online before a senior judge, but not necessarily, again, the one who's going to be in the appeal. And they won't be concerned with the arguments that you're having in the appeal. It's only the practicalities about making the case ready. And I do find these are very helpful. They're quite informal and they're very pragmatic. You know, it's basically, what do we do to make this hearing happen? And they are, when necessary, prepared to be quite robust. I've had cases, for instance, when a local authority wanted an adjournment because they vaguely hoped they were going to get a school, and the school was fairly tough about saying, sorry, the judge was fairly tough about saying, you know, you had all the assessment time to look at schools. You've now had 6 months whilst this appeal's been going on to look for a school. Do you really think you're going to find one in the next, 3 weeks? And is it fair on this child to have more delay? So, be prepared for that. I mean, they'll also be fairly robust with you or your representative if you're not doing what you should. But it can be a very helpful hearing. Next slide. They love it if you settle. They want you to carry on talking to the local authority. If you do settle, the local authority may tell you to withdraw. Please do not. They should always really be in the form of consent orders, really, so that you can make sure it happens, and get timeliness written in, that type of thing. And you can get a form for that from the tribunal. And it's usually fairly simple order. If it's a contents appeal, they'll attach the final version of the agreed working document, order the local authority to issue that, and arrange the school place. However, if you settle really late, less than 5 working days before the hearing will go ahead, and the parties might be asked to explain why it's late. I mean, I wouldn't worry too much about that. They are mostly going to be asking the local authority why they couldn't have done this sooner. Or if you have lawyers, they might expect them to have done something to get it settled slightly earlier. Also be aware that they don't necessarily rubber stamp a consent order, because they want to be fair to parents particularly. And if they could see that you've agreed to a working document that doesn't guarantee anything for your child, for instance, they might be prepared to say, no, we're not going to let this be settled. It is very rare, but it just occasionally would happen. Next slide. So at the hearing, usually online, usually 2 judges, occasionally 3 if it's more complex, or if it's one where they're being asked to talk about health and social care. Usually half a day, unless it's a school appeal, and it'll be a full day. And if it's an extended PAR appeal, that's the social care and health, they usually allocate 2 days, but the second day is just for them to make their decision. You could, if your case is really complex, ask for a 2-day hearing. And they will allow it if you can show that it's justified. You'll be asked to log on early to make sure that your connection works. And if anyone's connection disappears, they will stop and wait for them to come back in. Usually they start with introductions and the sort of housekeeping issues like late evidence, who the witnesses. And then they will usually say, well, we think these are the issues. and they will work through them in that order. So it looks like speech and language is an issue. It looks like one-to-one help is an issue, and go through all those one-to-one. And it's again meant to be fairly informal, user-friendly. If you're represented, most of the questions will be directed to your representative. If you're not represented, they won't be your representative, but they will consider asking the sort of questions that perhaps your representative might have asked, just to make sure that they're fully informed. And again, it's not the end of the world if you forget to ask a question and you sort of say, "Oh, sorry, I forgot to ask so and so this." They'll probably be reasonably flexible. Next slide. Basically, they do want to make sure that it's fair and you feel that you've had a fair hearing. And I've talked about the issue with the child. But in preparation, make sure you know that bundle really well, and you put something like sticky notes on the important documents so you can find them quickly. I would suggest making sort of a bullet point list to make sure you're not worrying about forgetting the points you want to cover, but don't read out a prepared speech. There's something about that that makes people switch off. And probably prepare a draft summing up. At the end of the day, you will probably have each side will be a chance to sort of summarize. And by that stage, your brain is likely to be fried. So it's helpful if you've at least done the prep before, to show how the evidence demonstrates that your child meets whatever the criteria are you're asking. But be prepared to adapt it, because it regularly happens that some really useful stuff comes out of the evidence that you'll want to refer to. But also be prepared to adapt it if you can see that something's worrying them from their questions, to try to sort of answer those points at our final opportunity. And next slide. Yep, you get your decision within 2 weeks. It's not going to be a massively detailed decision, but it should address the legal criteria and give enough reasons for each side to know why they won or lost. And you can only appeal against it on a point of law occasionally if they made a really blatant error on the fact. But you really need advice on that. So I think that is the last slide about appeals, if we can just check. So at this point, I can go into questions. Yeah. So are there questions in chat? Is it simplest if someone reads those out?
I'm just
and then perhaps do a hands up or something?
I'm just going to pause the recording.
So we're talking about various things that have changed in the law recently. If we could go to the next slide. So I'll talk first of all about the change program. This is part of the implementation of proposals which resulted from the Green Paper, which came out quite a long time ago about changes in SEN. And what they have started with is putting together groups of local authorities to trial various aspects of the proposals. And you've got details of who they are here, and you'll see Merton isn't one of them, which is fine. You probably don't want to be in a change program group, but that's just to see, just if you want to know. So next slide, please. So what they're doing is trialing various plans, various proposals in the improvement plan, which include there's proposal for sort of national standards, which will govern how how decisions are made. The new universal EHCP templates, which in fact they have now started using the current version, and the good news is it's not too bad. We're not often in that situation. So the idea is that rather than every local authority having its own template, there will just be one, and it's fairly similar to the current one, but what they are doing better is that they are aligning provision with needs. So it tends to have sort of 3 columns that say these are the child's needs in relation to speech, this is the provision for it, this is the outcome we want to achieve from it, which is how it ought to happen and hasn't really so much in the past. So sort of watch the space there. There are suggesting that local authorities, when they're consulting on placement, they can set out what they call a tailored list, which is one of the fairly controversial things, and also trying to encourage greater use of mediation. Next slide, please. If you are involved in any of the partnership areas and you find yourself dealing with these, bear in mind these are just proposals. The law has not changed. Chances are it will not change. There's going to be an election this year, and I think it will change to some extent, but not necessarily the way that the current government is proposing. And local authorities should make it clear that they don't have to comply, and in particular that the parents can nominate a school that is not on a tailored list. But we would suggest that you do sort of feedback on it if you're involved. So next slide. Smart transport. There was some guidance actually issued last year which changed things quite a lot. And then there was one thing in particular that they messed up, so they changed it again in January. And actually, again, the good news is that there are some improvements. Basically, that they have clarified things to address a lot of the problems that people have found dealing with applications for transport in the past. They've confirmed that each case has to be considered on its own, so they shouldn't be rigid here's policy. They're reminding local authorities that they've got an equality duty, so they've got to make concessions for disability, and particularly reminding local authorities that a child with special needs or mobility problems may be eligible for transport even if they live beyond the statutory school walking distance. If they live within the statutory school walking distance, which is either 2 or 3 miles, depending on age. We still see local authorities refusing transport to a child with SEN because they live less than 3 miles from their school, even though there's no possibility they could conceivably walk there. And this is, I hope, making it a bit clearer to them that you can't do that. Next slide. I think we need to go back one.
Sorry.
Yep. There's if you're only entitled to transport to your nearest suitable school. If the school they think is full, then obviously not. But if it should be the case that you are then put into the next school and you're getting transport, but the first school has a vacancy later, there's no expectation that your school has to move into that school. Obviously it wouldn't be fair that they should have to chop and change just to save the local authority a bit of money on transport. They're confirming if they're giving a travel allowance, they're giving something like mileage, that it has to cover the 4-way journey to and from. Previously, some local authorities were saying they would only offer that allowance for journeys when the child's in the vehicle, which was nonsense. That they can't take into account means. They've got to be able to meet medical needs. So things like if your somebody has to be capable of, say, using an EpiPen for a child with an allergy. And although a lot of transport policies say children have to behave, not surprisingly, if that means that the child gets chucked off the bus, the local authority has still got to meet their education duties. They can't say to the parent, tough, if they can't go on school transport, it's down to you, or they won't have any education. They've still got to provide some sort of transport. And also that they should give as much notice of changes as possible, because I suspect you've had the experience a lot of parents have, that you're only told that you've got a completely new taxi company 2 days before the start of term, and for a child who doesn't deal well with change.
Oh, have we lost Eleanor?
Eleanor is here, but Eleanor's now muted, and yeah, Eleanor, you're muted and your camera's also off. I'm just going to try to turn it back on from here.
Okay.
Can you hear me now?
Yeah.
Hooray, great. Okay. So yes, can we go to the next slide? Yeah. They give some guidance about risk assessments, that if a child is placed temporarily, say, in a PRU, that they still got to have transport. Sorry, this is slightly obscuring the slides. See if I can make it larger. Yeah, there's a basic rule for a child with an EHCP that that one of the reasons for refusing to name the school you prefer is that the cost of transport makes it too expensive. However, they do have to take into account whether the educational benefits of that particular school actually outweigh any cost difference. And they can also make a deal with parents that they will pay some or all of the travel costs. And if so, they should put that into Section I of the appeal. And what they can do, and from the local authority's point of view probably should do, is to say, we are naming XYZ school because the parents prefer it on condition that they pay the costs. However, we say that ABC school is a nearer appropriate school, and therefore we are not liable to pay the costs. And that is quite important, because what local authorities often do is say something like, we're naming XYZ school as a matter of parental preference, and they think that gets them out of having to provide transport. It doesn't. There is case law, which I think is on the next slide, if we could go to that, which says that if they, oh no, it must be a bit later. But it's a case called Dudley, which says that if they are saying that there's a nearer suitable school, they will have to name it in the EHCP. Otherwise, they will be stuck with, if they name the parental choice of school without any condition like that in it, they will have to pay transport. So next slide. Yes, the new what has changed in the guidance is that it says the local authority can take account of the risk that, although they've accepted that the parent's going to provide the transport, later on the parent might become unable to do it. But it's very unhelpful, because it doesn't say what's supposed to happen then. I mean, it does say that they could review the plan and reconsider, and they might amend it to name a nearer school. And they should write to the parent to say that it might happen, so to warn you that that's the situation, that if you've agreed to take your child, you are stuck with it, basically. But the oddity is this thing about taking account of the risk of them becoming unable to do it, because there's nothing that says they're entitled to ask for your means and how stable your job is or what your health is like. So it's all a bit odd, but basically the law has not changed. So next slide, please. So this is the one that gives that case authority, that if they can name a school conditionally on you providing transport, but they must name the alternative that they say is possible. Because if you don't agree with that, that gives you a right to appeal to the tribunal. If they just name it unconditionally, then they'll have to provide transport. So next slide, please. This is one of the controversial bits. I've actually gone into this in some detail, and I haven't really got time to spend too much time on it. But this is one of the big changes. Under the old law, it said that if it's a child who lives within walking distance, they are entitled to assume that the parent will accompany the child to school, depending on things like the child's age. So basically, they were saying that if it's a small child, you would normally expect to accompany your child to school, and that's what they'll expect for children with SEN. But they have changed that basically to say, in effect, that they would expect parents to continue to accompany their child to school, even if they're of secondary age. And that's quite a material change. And they've also said that they would accompany them, or they would make other suitable arrangements. So they're suggesting, presumably, that you might get somebody else to take them, or you might get a cab or something. And and that is really causes a lot of concern, because obviously most children of secondary age don't have to be taken to school, and it's prejudicing the parents of children with disabilities. because, you know, that's going to limit what they can do by way of work. It's going to cause problems with younger children who by then will be in a different school, that type of thing. And it actually sets out that things like work commitments or caring responsibilities doesn't make you eligible for transport. However, local authority must act reasonably. Next slide. It does say that they shouldn't have a blanket policy saying all of that, and they've got to consider the parents' reasons and depend on each individual case, and they should take into account things like parental disability. So they seem to be saying that that's the only thing they will take into account in deciding that you have to take your secondary age child to school. And they do give some examples which seem to back that up. Next slide. Yep. So they don't consider work, etc., and they get saying, "Oh, you're a parent." That's, you know, comes with the territory. They have noticed there's going to be a problem for secondary age children, and they say local authorities should be sensitive to it. But they don't appear to suggest that there's any sort of exceptions on that. So if you go to the next slide, which is why I'm saying this is wrong legally. So they changed the previous guidance. They talk about expecting parents to make other suitable arrangement, but the statute only refers to whether the child is able to walk, not whether the parent can make other suitable arrangements. So this seems to be an extra that the DfE has sort of invented. And the Education Act says that they can only assume that travel arrangements involve the parents if the parent's doing it voluntarily. If you're not doing it voluntarily, arguably that's breaching the statute. There's case law that says that they've got to consider whether it's reasonable to expect the parent to accompany a child, and you can argue that it's not reasonable to assume that parents will give up their jobs, abandon their other children to take their 14-year-old to school, and it is likely to be discrimination. So it's very controversial, this, and there are lawyers out there looking to challenge it. And interestingly, you may be aware we do sort of pre-action letters for judicial review. I've done a few based on these sorts of issue, and rather to my surprise, every single time the local authority has rolled over and given in, which rather suggests that local authorities don't really fancy defending this sort of case. So it's a sort of watch this space. I don't think it's a lawful provision, but you are going to, because local authorities are desperate to cut down on transport costs, you are going to see this sort of thing being relied on. So next slide, please. So yeah, there's guidance on behaviour in schools. It's a very, very big document. I'm not going to go through it. It was issued in, the current version is issued in February 24, but actually it's just a fairly minor update on some guidance in 2022. And I'm only going to look at a few bits that deal with SEN. So it gives quite a lot of guidance on what should be in schools' behaviour policies. And there's a lot of frequent reminders of the fact that schools should take into account special educational needs, and please remember your equality duty. So duty not to discriminate, amongst other matters, on the basis of disability. Next slide. So a few particular provisions that are available, particularly relevant to SEND, because everyone is worried about the fact that children with SEND do get excluded to a disproportionate extent. So they've got to be aware of those duties. They've got to think about triggers for problems and to put in place the support to stop problems happening, like movement breaks and having concessions on your rigid uniform policy for children with sensory problems and so on. And particularly remember their legal obligations. So you should not have a child effectively being punished for their disability. You know, if they can't sit still because they've got Tourette's, they shouldn't be punished for it. If they're having a meltdown because they've got autism and everything's got on top of them and the school isn't meeting their needs, they should not be punished for it. So next slide. So, however, they are sort of saying, however, that doesn't basically mean that it's SEND is a sort of a always an excuse. So don't always assume that their behaviour is being caused by special educational needs. But nevertheless, they should consider whether it's contributed, and they should think about adjusting the sanction. And there is case law that says it's really tidying up a problem in the previous law, which said that if you had a condition that's causes a tendency to cause physical abuse, like a child who'll just hit out when they're really dysregulated, the previous law was suggesting that is not a disability for these purposes, but there is this case law that said, yes, it is. So all the law around discrimination will come into effect. Next slide. I talked a bit about reasonable force because this will affect children more when you're using, particularly when restraint gets used. And there's separate guidance on it, which goes into quite a lot of detail, covering quite a broad range of things which might involve physical contact. And it's saying, yep, you can use reasonable force to prevent people from injuring themselves, committing an offence, damaging property generally for good order. And it also authorises things like conducting searches for various things like drugs, weapons, pornography, etc., things that might be used to commit an offence or to cause harm. But they again have to consider the specific vulnerabilities of children with disabilities and medical conditions. So next slide. Yeah, this is an issue which we're seeing quite a lot as problematic. I mean, not just for children with SEND, but it does seem to affect them again disproportionately. It's the use of isolation rooms. They refer to it in the guidance as removal. It's the practice of sending them out to go to an isolation room where they will sit and just, if you're lucky, they'll have some work to do and they'll be on their own and not allowed to mix with other pupils for a time. And it's problematic because some children really can't deal with that. It's sort of sensory deprivation. Or children with mental health problems may find it really hard to deal with. And so there is some guidance which does ameliorate this a bit. It says it's only in really quite extreme situations. They should have some sort of continuation of education, not necessarily what they were doing in class, but they shouldn't just be sitting there staring at the walls. And only for those quite limited circumstances to maintain safety, restore stability, following high disruption, let disruptive pupils be taken out so that education can continue, and to let them calm down. But it's a lot of emphasis that should be for the minimum period that's needed. You should not be having a child spending days on end in isolation. So next slide. Yep. So this are all the things that should be in the policy, that it's only a last resort, as it were, that the reasons must be clear. The behaviour policy should set out the principles about the length of time. So if your child is having this problem, look at the policy and see whether they are complying with their own policy about the length of time your child should be in there. The room itself should be an appropriate area and there should be resources there where they can work. And it should absolutely be supervised by trained staff members. And there should be a reintegration process. It's not something that's just left to someone's whim. Next slide. This is quite important, the next one. It's about schools monitoring data about how they use this room. Is it effective? If it's not being effective, if the same pupil's constantly in isolation, it's probably not working. Should they be looking at additional alternative approaches? Look at patterns. Is it always the child with SEN? Is it always the ethnic minority child? Is it always the year 9 child? It tends to be. So they should have that data. And if this is affecting your child, ask for that data. Are they keeping it? Does it show these sorts of patterns where someone's disproportionately affected? Are they analysing it? Are they using it sensibly? And a few other points which you see set out in the policy, with things like they should never be locked in except in really exceptional circumstances. And they shouldn't be removed for long periods without the head's explicit agreement, and they should have support. So again, make sure if this is happening to your child that they're complying with this. So then a quick look at some case law. Again, this is quite varied. Westminster City Council this was just an argument about is mentoring education, because provision, special educational provision in an EHCP has to educate or train, but there's obviously there'll be a lot of provision that isn't going to be actually actively educating and training the child. And one of the classic examples is something like a hearing loop for a deaf child. It doesn't train the child, but it enables them to be, or it doesn't educate them, but it enables them to be educated. And they said mentoring comes within that, or can do come within that that sort of category. And also it was just confirming a fact which we sort of knew but was being challenged, that you can have special educational provision outside the normal school day and outside term times, but it would have to be, you know, very particular circumstances, and there'd have to be good evidence to show that it's necessary. So if we go to the next one, this is a Bexley case. I'll sort of go ahead, which is about that test on whether. Can we go to the next slide? Should be OO and Bexley. Yeah, great. Should be about whether admitting a child would prejudice efficient education, which was that test for mainstream schools. And it's quite useful. I mean, it follows another case, but it's quite useful as a reminder. What should be, what local authorities and indeed schools and tribunals should be thinking about when it's being said that we can't admit your child because they would prejudice the efficient education of others. So they have to show that it's going to have a material effect, so that school or education for those particular children would fall below the efficient education threshold. So if this is a school whose Ofsted is saying it's providing an efficient education, they have to be capable of saying that at least for that class, the effect of having that child in there would have such an effect that for that class they wouldn't be providing efficient education. So it's it does show it's got to be quite a heavy duty test. And there's those points there. They have to be able to identify which other children's education would be affected. I mean, not by name, but something like it'll be the children in that class or that group or within the vicinity of that child. They have to be able to say that the standard of those children's education was already at or above efficient education standard. Rather oddly, if it was already below, then they're not going to accept that putting another child in will affect the class, because it's not going to make any difference, I suppose. And what effect would the new child's attendance have? And if it is going to reduce the standard below efficient education, is there a way of avoiding it, for example, by using reasonable adjustments? Next slide. Yes, this is quite an interesting case. It's a case which a parent brought themselves, and it's a judicial review case. It was in the High Court. And it was basically because Hertfordshire was being incredibly inefficient about assessments and seemed to be almost blanket refusing assessment to everybody. In fact, in this case, the parent had already taken the case to the tribunal and the local authority had conceded, but he was still carrying on with this judicial review because he was saying that he really didn't feel that they were operating a lawful process. And he pointed to the fact that Hertfordshire had conceded 79 out of 91 appeals in 1 year. And of the ones that they didn't concede, they lost them all except for one, which does seem to tend to suggest there's something wrong in Hertfordshire. And that's not, I doubt that that's confined to Hertfordshire. And the judge agreed and said this raises serious questions about how they're making decisions. And also dealt with the fact, which is very relevant today, that they're not completing assessments within a reasonable time period because they don't have enough educational psychologists. A lot of local authorities are saying this. Can we go to the next slide? And what the judge said was this quote: he accepted that it's difficult, but it's a hard-edged legal duty. You have to comply. Each time you don't comply, you are breaking the law. And that's the one I am now using in pre-action letters, saying, yep, I know that's your excuse, but you're not allowed it as an excuse. And they should be being creative. They should be buying in independent ed sites. They should be drafting them in from across the country if they need to make these things happen, that they keep the time limits. The parent had a further claim that the local authority was using these unlawful refusals to assess to manage demand. And that part of the claim was adjourned. And in fact, you know, what has happened subsequently is that some solicitors got involved and they negotiated a deal whereby the local authority agreed to bring in an independent barrister to check what was going on and whether the parent was right. So it was a good result. But I think it's an interesting case because actually it's one that I don't think solicitors would have taken because of the fact that this had been resolved in the tribunal. I think most solicitors would have said, well, no, you know, I don't think the judge will buy it. And so it's so good on the father. It's, you know, an unrepresented litigant going where solicitors fear to tread and getting really quite a good result out of it and highlighting a national problem. So can we go to the next slide? Just a quick look at, this is the last one. This isn't actually a terribly recent case, but it's a very current problem, I find, is children who are out of school for various reasons, either because there is no school for them, an increasing incidence of children who are out of school because of emotional and mental health difficulties, and the problem of getting them full-time education. And there's particular guidance for the tribunal on what should happen when this is what they're being asked to order in an EHC plan. And what governs this is Section 61 of the Children and Families Act, which says EOTAS, education otherwise than at school. Sometimes it's EOTIS, education otherwise than in school, but it means the same thing. But they're saying it can only be ordered if it's inappropriate for any special educational provision for the child to be given in any school, or indeed any part of that provision. So it's sort of, it doesn't mean it's looking at every single school in the country. You don't have to explore every school in the country, but it's any school that this child could reasonably access. And if they're satisfied that there is no school that child could access, then they should be ordering EOTAS. And they should ask whether the school wouldn't be suitable or proper, taking into account all the circumstances. And there's some examples there: child's background, their medical history, their needs, the school facilities, the facilities you could access outside the school, costs, parents' wishes, etc. So again, each individual case should be considered on its own merits. So it's not sort of rigid rules. You consider the cases, but if you have a situation where there is good evidence that there's just no realistic chance that this child is going to cope in school in the foreseeable future, or there's no reasonable chance you're going to find a school that's prepared to admit this child, then they should be providing EOTAS. And that should, normally be speaking, be, well, nominally full-time, although there is recognition that if it's going to be one-to-one tuition, because that's much more intensive than classroom tuition, it won't necessarily be classroom hours, but it should be a reasonable amount. I was talking to someone yesterday who was getting 6 hours a week and he was coming up to GCSEs. That's clearly not enough if the child can cope with it. If EOTAS is ordered for an EHCP, they should leave section I blank, and you should have the provision set out in section F so that it's enforceable. So that's the last of the case law. We've rather rushed through it. I don't mind staying on a little longer if it's sort of doable for you to answer a few questions.